Good morning, Mrs. Oshunisi. Mrs. Oshunisi, are you there? Can you unmute your mic, please? Sorry, we think we're dealing with some technical issues here. Mrs. Oshunisi, we're ready for you. You can unmute your mic. I think Mrs. Oshunisi is not. Okay, let me just recognize some few people that I see here. Okay, are you here now, Mrs. Oshunisi? Please, we're waiting for you, ma'am. Please unmute your mic.
Yes, good morning.
Okay, thank you very much. You're welcome.
Yeah, I have a little problem with my network. So yes, good morning. Good morning, Mrs. Ayodele.
She can hear you.
Yeah, I'm sorry, I didn't hear much of the introduction, so that's why I'm a bit lost.
To be around.
Yes, please welcome Dr. Babajide Martins. Mrs. Oshunisi, the floor is yours. You can go ahead. We already those of us who had seen the WhatsApp message, we know the objective of your session.
Okay. Well, yes. Good morning, everybody. I'm supposed to speak in respect of the role of a defense counsel in ensuring justice, and particularly from the perspective of the perspective of the prosecution. Well, the role and the ultimate responsibility of a defense counsel is either to argue his innocence or to try as much as to negotiate for defense to drop charges against the defendant or to reduce the charges against that defendant. And this can be done in a very, very professional and ethical which is the innocence. That is when the prosecutor knows that there are vast evidence, there are credible witnesses to argue such such innocence. But in dropping charges and in reducing charges, the defendant actually hand in hand. He has the privilege to work hand in hand with the prosecutor and the police, especially in cases where he believes or the defendant has actually owned up to him or her that, okay, maybe all these charges that they said I committed, all these offenses that they said I committed, I one of it. Try as much as possible to get me out of it. Yes, the defendant has the privilege to negotiate with the police or the DPP to drop charges against the defendant. In doing this, charges could be dropped where there is no evidence at all, where the witness is very, very unwilling to come to court, to come and give evidence, or where there is no admissible evidence to support. We as prosecutors, we are ready, always and willing to negotiate such. But the defense counsel, on the other hand, they see the prosecutors as always looking for conviction. That is not what we are for. We are here, we actually work for the community. We don't even work for anybody particularly. We have our role, we have our responsibility towards the defendant. We have our responsibility towards the victim. We have our responsibilities even towards the court. We are always ready and willing to negotiate. On the other hand, the defense counsel, they are of the prosecuting counsel are always out for conviction. That is not it. That is not it. We are not for that. We expect to work hand in hand for us to move the justice system forward. Then we also, as prosecutors, we also expect the defense counsel to know about all the available measures that can be employed, particularly the defense counsel by now should have been aware of the system of the plea bargain. There are so many measures apart from the system, apart from the plea bargain system. There is also the there is also the what we call restorative justice. There are so many arms of that one. The plea bargain, the defense counsel on its own could negotiate I'm sorry. The defense counsel could advise his counsel as regards the plea bargain. There are different arms to that. We have what is called the count baggage. We have what is called the sentencing baggage. And we have what is called the charge bargain. If the defendant should always be willing to advise his client if he or she has committed an offense to always plea bargain, come forward to come and plea bargain. Our doors are always open. The plea bargaining are there. They can plea bargain for the sentencing and ask that the sentence that is attached to the offense be reduced for them. They can also ask that the number of counts, if they have committed so many offenses within a particular period of time, they can ask that the counts be reduced or that the charges be reduced for them. But we find out that most of the time, these defense counsel, they are not ready and willing to advise their clients to that effect. We, on the other hand, we are ready and willing to always be fair. We are fair to everybody. We don't want to convict. That is not our purpose. Our purpose is fairness, to lay the cards on the table for everybody to see, even for the court. We take evidence, credible evidence to the court to go and tell the court that this person has committed this offense and the court should do justice. Now, another angle that we are looking at um, this topic about is the restorative justice. There is another way where the defense counsel could also advise his client, particularly as regards the restorative justice, which has the aim and purpose to repair the harm that has been caused to a victim. And basically, the restorative justice system is applicable to every offense, not only the minor offenses. But we find out that most of these defense counsel, they do not introduce or they do not advise their clients to go for restorative justice. The Lagos State government has actually recognized the restorative justice system as well, because it has come up with a procedure. It has come up in 2018. The restorative justice system procedure has been signed by the Honorable Commissioner for Justice of the state. The only thing is that under that procedure, that applies only to the minor offenses in Lagos State. It does not apply to capital offenses. Neither does it apply to felonies. So, but at the same time, a defense counsel represents only a defendant that's committed offense, which is not only a simple offense, which is not only a capital offense. You can also, they also represent um, minor offenses. So in doing that, rather than clogging the Kirikiri prison or Ikoyi prison with inmates, it's better that you advise those who have committed minor offenses to plead to restorative justice rather than them just facing trial, just being in detention for a long time and losing losing whatever they have and wasting their time. Now, another thing I'm going to talk about is the issue of how um, we expect the defense counsel to communicate with us in the Ministry of Justice, particularly in the Directorate of Public Prosecutions. There are so many ways. Basically, we expect that any defense counsel that has any complaint should always do a written letter first, make it formal. We advise that the council make it formal first. It gets to the office of the Attorney General before it gets to the DPP's office. Once it gets to the DPP's office, we invite the council over and we discuss about whatever he or she decides to negotiate with us, but not him or her going through the back door or just not bringing anything to us and just spoiling or diminishing the image of the office of the DPP. That's really my perspective of the duties of a defense counsel. Yes.
Okay, thank you. Yeah, thank you very, very much, Mr. Shunusi. I'm sure it's not a very easy topic to take, especially because you're actually speaking to a lot of defense counsels here. A lot of them have different opinions. So what I will quickly do is that I want to make this as interactive as possible. So please raise up your hands. We'll take 10 minutes out to probably react to what Mr. Shunisi has said, or we can take questions, or you can drop it on the chat box. One of the questions we have, Mrs. Oshunusi, is saying that is plea bargaining available for all offenses or for serious offenses that carry life sentencing? So that's a question regarding plea bargaining.
Plea bargain is a procedure that is open to any offense, whether capital offense or felony or simple offense. It is open to any offense. In fact, we've had so many plea bargain proposals from the defense counsel of so many cases that the particular committee in charge of it discusses, and it gets to the Attorney General. So it is open to any offense. It's not only simple or felonies, it's also open to a capital offense.
Okay, at this moment, I'm not seeing any hands up. So I'll quickly go to Dr. Martins. Please, we're still going to have an open mic session where everyone can comment and tell their story or give their experiences. So let's go to Dr. Martins for now. Thank you, Mrs. Adetutu Oshunisi. Please stay close by, so that just in case we need you to answer a few questions. Thank you. Dr. Babajide Martins, over to you.
Good morning, panelists and the organizer. Yes, in looking at this topic, I've got some highlights which I want to discuss vis-a-vis the duty of a defense counsel. I think for me, the starting point is this. As a defense counsel, the Constitution guarantees presumption of innocence for all people charged with offenses. Section 36, subsection 5 of the 99 Constitution as amended. So this is my starting point. So when I'm speaking to a client, I believe the client is presumed to be innocent. And it doesn't matter how the prosecution think how strong or robust their evidence is, they still have to prove their case. And that is for my own humble opinion. It doesn't matter how strong the prosecution case, there's always going to be loopholes there, which the defense will take advantage of and be able to get a not guilty verdict. And two issues now arises from that. As a defense counsel, are you obliged to advise your client to plead guilty? And my position is that no, you are not obliged whatsoever to advise your client to plead guilty, because there is a presumption of innocence that is constitutionally guaranteed. In fact, he's not even obliged to enter any defense whatsoever. If you know that the prosecution case is so bad, you would even advise your client not to enter box and base your defense on the prosecution case. However, the danger there is this: by your client not giving any evidence, you are assuming and legitimizing the prosecution's position that everything they've said, you don't have any qualms with it. So the court can give probative value to their witnesses. So it's not the most ideal strategy in terms of a good defense counsel. But when you know that the prosecution case is so wobbling, then you can say, look, we are relying on the prosecution case for this matter to be dealt with. We do not intend to call any evidence, nor is the defendant ready to come in. That is one issue. The other issue is this: do you now oblige your clients the advantage of a plea bargain, I think it's very, very important you let your client know about the merit of plea bargain and advise him vis-a-vis the case and circumstances of the particular case he's facing. If I think the case is watertight, and I can tell you quite unambiguously that I know a case that is watertight, having been a prosecutor for over 20 years, both in England and Nigeria, I will be very, very quick to advise a client and say, you better jump at the opportunity of a plea back if I know the prosecution case is watertight. But if I think the prosecution case is not watertight, I don't think it's advisable for you to ask your clients, maybe they want to plea or not. But ultimately, the decision is not yours. The decision belongs to the client, but you need to explain to them the implications and consequences of each way they choose to go. If they are minded to plead guilty, the implication and consequences. If they are minded not to plead guilty, the implication of consequences. You must make it so unambiguous that they know what they are letting themselves to. You owe them that professional duty of care to make sure that you do the best defense for them. And moving on, the issue of confidentiality is also very, very important. Are you obliged to reveal whatever the advice that you've given to your client or whatever confidential information your client has got? Of course not. If you do that, you are liable to professional. You are not allowed to give confidential information which you get from your client to the prosecution. It is not your duty in helping the prosecution to prove his case. So this is very, very important when you are cross-examining the witnesses brought by prosecutions. So the ideal strategic way is not allowing the prosecution witness have a second bite at the cherry. And the only way not to have a second bite is to ask close questions, give them the opportunity to have to explain better or to have to explain things which they've overlooked in their evidence in chief. Because if you are doing that, you are also compromising the case of your clients. So a strict yes or no question will be ideal. So the only time you know you want to allow them to make explanation is when you are so sure in the cross-examination that you know that they have some information that if you elicit it from them, it will be advantage to your client. That is very, very important. I think I'll now move on to the issue of can clients be rest assured about the outcome of the case? Of course, you can give your client assurance about how good the case is, but you can never give your clients definitely we are going to win this case, because there are so many external factors that is outside your control. So you will never be able to advise your clients. You will never be able to advise your clients that definitely you will win this case. And that is the position of the Supreme Court in the case of Abubakar and Yaradua. The Supreme Court held in that case, it's okay for clients to be given assurances how good their case is, but they can never be assured that with certainty they will win a case. If they do that, it's amounting to professional misconduct on their part. You cannot do that. You cannot give them that assurance that they will win their case by all means. You could indicate percentage. You could say, well, the odds are like 70-30. You could do things like that. You could say 80-20, 50-50, but you cannot give them specific assurance and guarantee that they will win the case. If you are doing that, you are misrepresenting your duty to them. So, which is very, 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 very important. And also, I also want to discuss the issue of counsel discretion. Can a counsel refuse a brief? A counsel who has advised a client to take a particular position, if the client fails to adhere to that advice, the counsel is entitled to withdraw his services. If he knows his advice is client to take a particular position and the client, against the professional advice of the counsel, says, no, I don't want to take a particular position, then the counsel in that situation can withdraw their services. But however, we as public defender, we will not withdraw our services, especially where the defendants are facing capital offenses like murder, manslaughter, or any terms of imprisonment. But if we know that we give them a particular advice and they decline, and the decent thing for you is to be able to say, look, because I'm likely to be professionally embarrassed by this decision of this client not to adhere to this particular information, by this particular advice, I'm professionally embarrassed, you will be able to withdraw your representation. But generally, under Rule 24, all counsel have a duty to accept any that has been given to them, provided professional fee has been paid. And that's why you get our colleagues from private bar saying, my brief has not been perfected. Of course, if your brief has not been perfected, nobody will expect you to go ahead and represent the client. But you owe the court a duty to notify the court and notify them well enough as to be able to give the client the opportunity to get another representation. So under Rule 24, professional conduct for legal practitioner, that is a justification for you to refuse to act for a particular client if your fee has not been paid. But however, because the Office of Public Defender is funded by the state, we cannot have that justification. That means all brief must be litigated on behalf of our clients, except the only situation which I've mentioned is that if you think by giving professional advice to a client and the client wants to go ahead and refuse the advice, and you know that he's very likely to expose himself to further danger. Let me give you a typical example. If you know your client has committed perjury and that information is at the disposal of the prosecution, and you know that the prosecution is likely to use that information to its detriment, it's also likely to add more charges to perjury, which I think is 5 years, and the man is probably facing an offense for conduct likely or breach of peace, which would have been something like 6 months. And you know, while preparing for this case, he has committed further acts of perjury. I will advise the client to plead to that breach so that he doesn't expose himself to more serious charge of perjury. The client says in that circumstances, I don't want to plead, I haven't identified the reasoning behind the advice to them that they're exposing themselves to further and more serious criminal liability, I think is within a client's right to refuse to represent that person. That will come under the justification under Rule 24, which allow you to refuse to represent a client, to refuse to take a brief in circumstances that you know you'll be professionally embarrassed, or you know the client by their own conduct are exposing themselves to further criminal liability. I think those are very, very important. But generally, the court has said that the counsel are obliged to attend all sittings, and those are the decisions in Okonofua and the states, and FRN and Abiola. Counsel are obliged to attend all sittings. There is nothing known as conditional appearance under our jurisprudence. If you take a brief, you are to attend to all the proceedings, and you owe your clients the duty of care to ensure that if you are not going to be around, to send somebody to hold your brief, and not holding your brief, to fully appraise that person of all the facts and circumstances of the case so that the person does not go to court to compromise your client case, because the primary responsibility lies with you as a client, as a counsel. So if you call another counsel to brief on your behalf, you are vicariously liable for any wrong that will be committed by the counsel who is holding your brief, because the original brief was between you and the client. So if you are now person to hold your brief, if that person commits any atrocities or anything, if his conduct becomes unbecoming, you would have to take that responsibility because you are vicariously liable to your client. I think those are the observations that I want to make at this moment. As time goes on, and with other discussants, I will also be able to mention other things. Just to reiterate, I've mentioned everybody is presumed innocent under Section 36(5) of the Constitution. You do not have an obligation to assist the prosecution to prove its case. You do not have an obligation to compel your client to plead guilty. You do not have an obligation to provide information at your disposal which you think might assist your clients. But if you know that that information can also potentially bring your client to some further criminal liability, I think it's incumbent on a competent counsel to advise the client and expect the client to adhere to your advice. If the client failed to adhere to your advice, I think you are within your legitimate rule to withdraw your services. And I reiterate, but because we are public defender, we would hardly take that decision to withdraw our representation for a client. If we know that there's further criminality or there is imminent danger that will compromise our client interest, I think we can make an exception to withdraw and ask the client to do so and get alternative legal representation, bearing in mind the need for you to notify the court and also notify the court on time. But you are not obliged to notify the court as to reason why you are withdrawing your services, because you owe your client a duty of care and confidentiality, because your discussion with your client is privileged information. Under the Evidence Act, under rules of professional conduct, nobody can compel a client to come and give information about the advice he has given. And I know there is an ongoing case. I don't think the Supreme Court has ruled on it, where a client know or have informed, where counsel have informed the amount of money to pass that information to the authority in order for his client to be investigated. I don't think that decision has been resolved one way or the other. I know the earlier decision was that the client owes a duty of care and confidentiality, the counsel to his client, so he must not disclose any information, even if the information amounts to criminal offense. And I know that Department of Trade and Industry is trying to get that law, that aspect or that directive that counsel should inform the authority when they know their clients are involved in money laundering. Even in England, the obligation is not there. Once you get the information in the course of your brief, provided you are not part of the conspiracy for the offense, you are not part of the money laundering. If you are part of the money laundering, then you will be charged separately by the authority for conspiracy. So those are my initial observations. Thank you, Mr. Moderator.
Thank you, Doc. That was very, very revealing and educating. Before I go to Mrs. Ayodele, who I've asked to speak generally on the issues of professional ethics in navigating how we conduct our affairs. I wanted to give the mic to Mr. Babatunde Ogala, and then I would transfer that to Mr. Charles Adeogun Phillips. I mean, those of us who don't know Mr. Babatunde Ogala, I mean, he's he's um, he's been, well, most recently a member of the House of Assembly. He's a lawmaker as well as somebody who has been in practice for very many years, and as I believe he's done some prosecution work. I'm not sure, but he's a defense attorney that we all know very well. So, Mr. My Honorable Babatunde Ogala, let's have your thoughts on what has been discussed so far and generally on the topic.
Well, thank you, Bayo. Let me say this is an ambush. It's an ambush because I've come here to learn. I was not meant to be a speaker. And I was already even preparing my questions for Mr. Martins. But nonetheless, I'll say thank you for the privilege. I found the subject interesting because when I saw your message to attend it, just my mind just flashed back to the making of the criminal law and most of the law review we did in Lagos State, where incidentally I presided as chairman House Committee on Judicial and Legal Matters then. But in so saying, I just want to, again, like I said, I'm here to learn, to seek clarification and knowledge from Mr. Martins. In his presentation, he spoke about you not being obliged to advise your clients to plead guilty to an offense. I see a conflict here. And what is the conflict? You know, the rules of professional conduct tells us as counsel, our primary responsibility is to the courts. We are said to be officers of the courts, be it as defense counsel or prosecution counsel. And if that being so, and there are also a plethora of authorities that say whatever information or knowledge that you have that could assist the court, even at the detriment of your client and your case, you are obliged to give it to the court. And I've used that authority a few times at the Supreme Court, and it keeps recurring. And that's why I said maybe there are conflicts. Now, he has also gone further to talk about a plea bargain. What is a plea bargain? A plea bargain is advising to plead guilty, albeit perhaps to a lesser charge and a lesser sentence. So, by the same token, if I pick up a matter and I get the proof of evidence and I go through and I talk to my client and it becomes clear to me that this is an offense or that the prosecution case, even on the face of the information, I would appear that this man can just not get out of this. What then do I do as a dilemma? Yes, I agree. You may not want to lead evidence, but if that would help your client and save the time of the court, is it not better to advise him to plead guilty or enter a plea bargain like you advised on the flip side? And in so doing, to my opinion, you are helping the cause of justice. In my opinion, you are saving the time of the court. In my opinion, you are also even helping the defendants. I have a particular matter I'm doing, and I will give you. It's a homicide-related matter where somebody was initially held for murder. By the time the investigations went and the advice came, the state saw that or recommended that it could be manslaughter. But we went further into discussion, and we said to the we went to the to discussion with the prosecution agencies, and we were able to bring this charge based on available facts down to a charge of that will carry about 5, 6, 7 years imprisonment. And on my part, I thought it was best to advise the client to plead guilty to the lesser charge. So, in my opinion, I think it might not be too correct, or I stand to be educated to suggest that we cannot, as counsel, advise clients, or we are not obliged. Or I also note that you also use the word compel. You know, those were the three words used intermittently.
Low battery.
To plead guilty. If I cannot, if I think I am obliged in the first place to advise that, and I know I cannot compel. In that circumstance, am I obliged to continue with the matter? Then coming to providing information to the court, again, these are all things that are also unclear. I'm not unconscious of Ibori's case in the UK because where the council also had to come in for money laundering and ended up being. I'm not also unconscious of the case of Nigerian Bar Association Board of Cooperative Trustees and the federal government of Nigeria on, is this common? What's that? Where lawyers are supposed to make returns and we have pleaded this issue of confidentiality. I'm not unconscious of that. But I'm also not unconscious of my professional obligation to help the court to arrive at the course of justice. This, for me, I wish to be educated by the experts as aware on how we can navigate, on whether in the course of a trial, for instance, you have perhaps or you have things that could help. Because there's a misconception, really, that lawyers are supposed to, that's why they also call us liars, badly. That they say lawyers are liars. We are not. It's based on the facts presented. But of course, we are also
Honorable Ogala, your audio is being interrupted.
Low battery. Please charge.
Mr. Moderator.
Yes, I think Mr. Ogala had finished, but we didn't hear the last part of it. Mr. Charles Adiogu Phillips, do you want to speak now, or you want Dr. Martins to probably say one or two things first?
It's really open to you.
Low battery. Please charge.
Well, maybe you can just continue then. Dr. Martins can take everything together and give us his opinion at the end of the day.
Okay. Good afternoon, everyone. I have listened very carefully to the questions. And let me apologize for not showing myself. I'm very undignified in my dressing this morning.
Low battery. Please charge.
It's my day off work. But let me try and contribute to discussion from the perspective of someone who practices both as a prosecutor and defense lawyer, depending on which jurisdiction and myself. You're aware, it is possible for you to be prosecuting by way of fiat in one
Low
day
battery.
and next week.
Please charge.
Unlike is the position here, we are not stopped from playing both roles. Now, since the discussion concerns the defense, my first point is that contrary to a lot of things that people say, the primary responsibility of counsel,
Low battery. Please charge.
prosecution or for the defense, your primary responsibility is to the court. Your primary responsibility is to the court. As regards the rights of the defense, we operate in an adversarial system of criminal justice. And as part of an adversarial system of criminal justice, the burden of proof in any criminal
Low
case
battery. Please
lies
charge.
squarely on the prosecution. The discussion that I've heard seems to suggest, at a minimum, that the defense has a burden to discharge. that is not correct. The defense carries no burden whatsoever. And their job simply is to raise doubt in the prosecution's case. And
Low battery. Please charge.
any doubt that is raised on behalf of the defense must be resolved by a court of law in favor of that defendant. That is to say that the job of a defense counsel essentially is to ensure that the fair trial rights of the defendant or the accused person is upheld at all costs. Be it a fair trial right of a defendant in relation to a police station interview where the process really starts from arrest, from interrogation, arrest, the search of his home, his ability to be informed promptly of the charges against him, his ability to have an interpreter of choice and to have counsel of his choice if he's indigent. These are factors that are relevant for defense counsel in a criminal trial. If we then move to the issue of plea bargaining, there is a bit of an anomaly in the law as far as the federal system is concerned, in the sense that the Administration of Criminal Justice Act tends to suggest that the only time where parties should be encouraged to enter into a plea bargaining arrangement is when there is an insufficiency of evidence. Now, I don't know any defense counsel in the world who would allow his clients to enter into a plea bargaining with the prosecution when the evidence simply does not exist. And that is a problem with that legislation in itself. The whole purpose of a plea bargaining, as Mr. Martins clearly pointed out, is multifaceted. From my experience as an international prosecutor, an average criminal trial before an international court can last 3 years. And they cost so much because defense counsel are drawn from all over the world, and there's forensic evidence and this. And because the life of those courts are limited, every opportunity to get a plea bargain or to get a guilty plea is encouraged for many, many reasons. It aids reconciliation. And that has to be the primary reason that you be seeking to plead guilty. It actually aids reconciliation. But beyond that, a defendant that pleads guilty is able to secure a tactical advantage if the guilty plea is timely. Now, if you plead guilty, even if you surrender yourself, in the UK, you get the most advantage in the sense that there is a sentencing tariff. There's a sentencing tariff. So for example, for offense of theft, so it's 7 to 10 years, depending on the nature of the aggravation or the mitigating circumstances. If you plead guilty and you surrender yourself, you are likely to be leaning towards the lower end of that sentence. Now, at the end of the day, it's a feature of the evidence. And we look at the evidence and we think, well, the evidence is strong, but maybe the main prosecution witness is, we're unable to secure the main prosecution witness. Or there are many reasons why we cannot carry on with this trial, or this or that. And we approach the defense and we offer them a plea. Now, any sensible defense counsel will be looking to minimize the accused. And as the first speaker rightly said, there are different types of bargaining. There's a charge bargaining, there's the sentence bargaining. And it all depends on what the circumstances are. In the international criminal area, we actually extended that further to actually bargain where the sentence will be served. In other words, there were certain accused persons that said, I would like to serve my sentence in Sweden, for example. And we threw that in as part of the, others would say, I would like to assist the prosecution. For example, if it's a conspiracy charge and the evidence is stronger against some main players in the conspiracy, but we have this foot soldier who is willing to offer us a plea, but his evidence as to the insider evidence as to what took place in the planning of the offense is of such nature and of such import that it will contribute to securing a conviction against the bigger wigs, then we would cut a deal as prosecutors with the foot soldier in order to, as it were. So there are quite a few things that go into deciding whether or not a guilty plea should be offered, or even the bargaining process. And in our experience, one of the difficulties we have in this jurisdiction is the inability of a sentencing tariff. Now, you are unable to enter a bargain with a defendant if you're not able to assure that defendant that, look, if you plead guilty to X, you are likely to be sentenced to within 3 or 4 years or 6 months or 9 months. Judges need to be able to indicate to us by way of a sentencing tariff what a defendant is likely to get. That aids the negotiation process. That aids the negotiation process. So if you do not have a set tariff, then it's actually then difficult to be able to enter into bargain. The other experience I have is that our judges bound by guilty plea agreements. So for example, can I enter a discussion with the prosecution in Lagos State and enter into an agreement? And if we take that to a judge, would the judge feel bound by the facts that we agree on, the range of sentences that we're recommending to the court, etc., etc.? Can a judge just tell us, I don't agree with this mode of participation. I don't agree with the facts that you rely on. They're inconsistent indictment or the charges, and I will not accept this guilty plea? Or is it a situation whereby when we arrive at a guilty plea negotiation following the bargaining, we then go back to amend the charges to reflect those facts that we have agreed upon? You see, because if you agree on a lesser of conduct based on a certain kind of facts, you cannot then rely on the existing charges before the judge. The judge will say, well, what you've agreed on is inconsistent with the charges before me, and in relation to which the accused person has pleaded not guilty. So again, defense counsel, it behoves on defense counsel to go back and say, well, okay, we've now agreed that he stole an orange and not an apple, but the indictment says he stole 2 oranges. Do we need to go back and amend the charges to reflect the fact that we have agreed that his mode of criminal conduct will reflect the fact that he stole an orange? Can I just stop at this stage and allow other people to contribute to this discussion? Thank you very much.
Thank you very much, Mr. Charles Adeogun Phillips. Your wealth of knowledge is really amazing in this regard. Dr. Martins, do you still want to settle down? And Mrs. Osunusi, maybe we settle down and then we still take a few more discussions on the matter, or how do you want to play it? Do you want to just jump right in? Just tell me what you want. You can unmute your mic.
Low battery.
Yeah.
Mrs. Osunusi, do you still want to listen to other people first and then contribute later?
Is it from my end?
Well, I have forward my own view, the role of a prosecutor. Maybe I should listen to whatever anybody else has to say about a prosecutor rather than me pushing forward first.
Okay, great. So Dr. Martins would also hold on. Let's hear from Mrs. Ayodele. Like I said in the beginning, Mrs. Ayodele is here to kind of give us a general perception or perspective on the issue of professional ethics. These are the nitty-gritty of our behavior towards cases, our behavior towards each other in terms of how does the defense lawyer see the prosecution? How does the prosecution see a defense lawyer? Given her age at the bar, she's retired now, so she can bring the past to the present and the present to the past, I would say. Mrs. Ayodele, thank you for coming out of retirement to do this.
Good afternoon, everybody. I'm glad to be here. I've listened to the panelists and the 2 other contributors, and I've been the 3rd one. First of all, I want to say that basically everything we rely on is on the place of the rule of law. The rule of law is essentially to prevent anarchy, creation of a just society where everyone is equal before the law. At no blame, we must understand the fact that the population of the country, particularly in Lagos State, where we live, we understand the fact that from reliable statistics said that about 80,000, and because of this, of the negative things that have been happening, a lot of crimes have been committed. There's been a surge in crime rate in Lagos State, and that has increased the number of cases that goes to court. So I'm going to speak particularly on a way where there will be no delay in justice, and then judgment becomes speedily. Because of this, we must ensure that cases that come to court from the police station are properly investigated, and everything is tenaciously sent to the office of the DPP so that necessary legal advice will be issued, and then prosecution can commence in court. And when we are in court, the counsel for the prosecution, both sides, have a duty to the court. But the counsel must ensure that they present all the facts of the case properly before the court, and then they must also ensure that cases that come to court are speedily entertained. There must be no unnecessary delay or unnecessary adjournment where counsels are not ready, or for one flimsy excuse or the other, cases are delayed. For instance, on the issue of prosecution in court, there has been this subpoint of trial within trial. That's always caused kind of delayed prosecution in court. This trial within trial is like, in my own view, it's like casting a burden on the judges, because they have to do a mini trial, and at the end of the day, they do a proper trial. And because of this, that sometimes negatively affected other accused persons in the matters who have a defense of having their matter to be done trial within trial. But they have to stay in custody, especially if they are not on bail, until that matter is dispensed with, and then they now begin the proper hearing in court. So I just want to emphasize the fact that we must, as much as possible, try to ensure that there's no unnecessary delay, so that at least the congestion that we're having in court and then the prisons are minimized, and then the workload of the judges are also not much. In the area of cooperation between counsel, both in the Ministry of Justice and outside counsel that are usually the ones defending the accused person, they must ensure that they do not do the untoward. I've had the experience of having counsel kind of maybe conspire with counsel in-house and kind of ensure that some of the exhibits or whatever that were in the police case file are somehow removed from the custody of the files that we have in the Ministry of Justice. This is a very bad professional ethic that should not be allowed and should be discouraged. When counsel for the defense want to come to the Ministry of Justice, they must come with a pure mind and not with the view of trying to distort whatever it is found in the court that may jeopardize the matter when the matter comes to court. And usually, the office of the DPP is an open place. It's not a place of hide and seek. Counsel can come in and state their cases and all of that. And counsel, essentially, the prosecutors, is not that they want to seek conviction at all costs. What they want to, of course, the law says that it is even better for 9 accused persons to go out of jail than for one person that is innocent to be jailed. So as much as possible, there must be cooperation between the two counsel in the case, both the prosecution and the accused persons. And on the issue of plea bargaining, plea bargaining has always been there, but now that the courts are now operating it, the concern of the laymen is that where will somebody steal so much money, and at the end of the day, the plea bargaining is done and it's left a life sentence, or is made to pay a fine that is just so minimal compared to the particular money that the accused person probably will have stolen. So that area that is still not clear. I don't know how the plea bargaining will be commensurate to what the amount of money that has been stolen or for the offenses that have been perpetrated. I don't want to speak about counsel. In my days when we were in the Ministry of Seniors that always lead us in court, we are not left alone to do our case. After a lot of tutelage, it is only then we can stand on our own. I don't know what operates these days, but I remember in those days, we had very sound learning senior. Most of them have been judges, now retired, like Justice Odvivo in the Supreme Court, Justice Manuel, Justice City, and a whole of brilliant seniors we had at that time. I think a lot of people, if they must have heard of Justice City. He was such a fantastic judge and a mentor. Leader. As a matter of fact, you always make sure that you are well grounded. You are so confident when they are in court, they can stand on it. That tradition must still be maintained. The seniors that are there now must be able to engage the junior ones and take them through the rudiments of the law, how to conduct their cases in court. And then lawyers must also be, the way I see lawyers, sometimes they behave in a way that is untoward. You see some lawyers, I don't see the reason why lawyers should go out of court and not remove the collar and beep. I can imagine seeing a counsel riding on Okada with his collar and all of degrading the position of our profession, which is very noble. As a matter of fact, when I see some counsel behaving in such untoward way, I begin to wonder that why are counsel diminishing the position of lawyers? Also be people that will be respected in the society. But these days, the people outside, the way they see lawyers is not the way they used to see lawyers in those days. And it's going to be very wonderful and nice that we go back to the old ways. And I do not believe that lawyers just coming out from the law school will start their own practice immediately. A, B, and C, and Co. They are not really grounded enough. They need to go through some mentoring. And there must be a law, some whatever it is, that will ensure that you just don't come out of the law school and jump into practice. You must undergo some tutelage. That is where the Ministry of Justice is so wonderful. It's like a place where you are grounded, very well grounded, and you are a total counsel because you go through the rudiments of the different divisions of practice. You are in civil, drafting, and all of that. I think there must be a way to ensure that young counsels are under some mentoring before they jump into practice. That is why we have a lot of sharp practices where sometimes we wonder some cases that come to court that shouldn't come to court, and the attitude of lawyers, even when they're in court, the way they conduct themselves, they are not civil. And I also want to go to the area of appearance. The way these days, when you see counsel in court, the way they dress is not the way that we used to know. I'm sorry to say, you see some of my female colleagues, you see them with funny hairstyles. Some of them put some colors that are not even white. They now use their wig, their gown to cover their clothes. And I don't get it. I don't know. There's need for us to go back and go to the old way. Although we're in the new normal, I don't believe that is the new normal. That we should wear, putting all kind of funny colored shirts and blouses to the court. That area too must also be addressed. And also we want also encourage seniors as well to ensure that the pay they give their junior counsel is commensurate, at least a living wage, so that at least they'll be able to live well and at least a bit comfortable. The Minister of Justice has been doing wonderfully well, and I want to encourage them as well now that counsel in the Ministry of Justice, they should also be well remunerated. They should give them a lot of incentive because they are doing a lot of yeoman's job. I can imagine the number of case files that the Department of DPP, have now compared to what I had when I was DPP some few years back. The government, we know the economy is not the way it is, but at least there should be a way to encourage counsel in the Ministry of Justice and even the junior counsel that outside in practice. A lot of things that I needed to discuss upon have been mentioned, so I won't want to belabor everybody. Go back to what my colleagues said about plea bargaining, talks, and even to the society. So I just want to thank convener of this seminar, Mr. Bayo Akinlade. He's been doing a good work, and we pray he continues to do it. Unfortunately, he didn't come out winning the position of vice president of our in the fullness of time, he will be rewarded. Thank you for listening. Have a wonderful afternoon.
Thank you very much, ma'am, for coming, and thank you for the kind words. Dr. Martins, are you settled down now to respond and to add a few more things to your paper? Dr. Martins? Dr. Martins, we can't hear you yet. You have to do something about your audio. Maybe you should use a headpiece if you can. Okay, while we wait for Dr. Martins to get settled down, Mrs. O'Shaughnessy, do you want to say some things before we will open up the mic? Please, if you want to make a statement, just raise your hands up and we will have you unmute your mic. Thank you.
As all that I said, the vital issues, maybe just to keep encouraging keep encouraging. Hello, are you? Can you hear me?
We can hear you. I can hear you.
Please?
Yes. Yes. Carry on.
Okay. Just to keep encouraging counsel of the DPP to always feel free. They have rights to approach DPP for in favor of their counsel, in favor of their client. They should not make any effort to keep things to themselves. If at all they know that their counsel or their client has committed an offense, there are so many ways they can go about it. Rather than make their client rot in detention and at the end of it get punished for a very long time, whereas there are always the plea bargain proposal that they can always put forward. Once the plea bargain proposal gets to in fact, the office of the DPP itself, we also have the privilege to propose a plea bargain to a defendant, especially where we have found out that there are no credible or sufficient evidence to establish his culpability. So the plea bargain issue is a very straightforward something. Once the counsel realizes that the defendant has committed the offense, they should advise them to plea bargain. And with that, the plea bargain system will grow and it will have a very long route in our system. That's all I have to say.
Thank you very much for that. It's very clear that plea bargaining is one of the things that we need to educate a lot of lawyers on, and the process is still ongoing. So, Dr. Martins, are you with us now? We still can't hear you. I think we probably need to get better funding for OPD in terms of technical issues. But you were very clear, loud and clear at first. So please, if you have, if you want to make a comment, please raise your hands. I think we still have about 20 minutes left. Please, anyone who wants to make a comment, raise your hands. Okay, Mutiu, great. Mutiu, please.
Back.
Yeah. So introduce yourself, Mutiu, and then let's have your contribution.
It's happening already, Mr. Bayo, for this wonderful initiative. I work from Abuja and to share a little experience of what we have here, particularly when it comes to prosecution of. It's been extremely difficult to implement the day-to-day hearing under the ACJA. And one major reason for that is because we do not have enough prosecutors. You find a situation where one prosecutor shuttles several courts. And if he or she is not available in a particular court, all the matters in that court are then adjourned. And that affects the administration of criminal justice. You see matters being adjourned, witnesses get tired of coming to court. And after a long time, those matters are struck out. And then the whole system is just not working. I do not know what the situation is in Lagos, but I'm sure our resource persons may want to share with us how they're solving these kind of problems in Lagos, so that we can also learn from it and then see how in Abuja we can also borrow a leaf from Lagos and get the system working. So that's my comment. Thank you.
Okay, thank you very much. In fact, that was one aspect that I had missed, really, that one of the incidents of delay in prosecution of cases is due to the inability, or basically the numbers of prosecutors that we do have available. So, Dr. Martins, are you set now?
Yes.
Okay, yeah, please
Can
go
you
ahead.
Can you hear me now?
Yes, I can hear you very well.
Yes. I think I need to take exception to that remark. I think it's regrettable to say we should get proper funding. OPD is one of the best and well-funded agency. I think I'm taking exceptions to that. I found that ridiculous and offensive. That's
My apologies.
Just by the way.
My apologies.
Yes. I think in relation to Mr. Ogala, I think Mr. Ogala seems to quote me out of context. I was saying the issue of you not being obliged to advise your clients to plead guilty is a purposive interpretation of section 36(5) that says everybody is presumed innocent. So that is the fallback upon which I made that assertion. Of course, the courts in Nigeria and England are quite settled. You are first and foremost an officer of the court. And Rondell, in the case of Rondell and Worsley, Lord Denny has set out that duty quite elegantly, which has also been adopted in the Nigerian case of Free Enterprises Nigeria Limited and GTO SA, to the effect that your duty is first and foremost to the court. However, if you get information which you know that you're obliged to disclose to the court, which is going to be to the detriment of your client, you have the discretion to advise your clients to either plead guilty to a lesser offense or to change counsel. That is the point I was making. And the typical example I gave was that if a client is being prosecuted for breach of peace and you advise him to plead guilty and is insisting that he will not plead guilty, and you know, having gone through the paper, you see some other charges that can potentially come, and he runs the risk of, for example, being charged for perjury, which is 5 years. I think you owe your client a duty of care to advise them to plead guilty. And if they refuse to adhere to your reason, I think it's professionally incumbent on you to withdraw your service from them. And I also gave a caveat, and I said, in withdrawing your services, you are not to withdraw your services at the last minute as to jeopardize the defense of your client. You owe the duty of care to the court to give enough notice to your client to make alternative arrangement for his representation. And I also said, in situations where people have been charged with capital offenses or more serious offenses, we will not, and it's not expected of you, to withdraw your defense counsel for that particular client. You just need to advise them the risk which they run at because of the availability of information which you know that will likely embarrass you and also compound their own case. I think I'll make those comments on Equivoca. I'm not able to react to what Leonard Mrs. Ayodele said because I was not able to hear most of the discussion. I think, of course, the position of the law and also professional conduct rule is that you are first and foremost an officer of the court. But I'm saying if my client's role conflicts, I will either have to get my client a soft landing by asking my client to plead to a lesser offense. I will not jeopardize the interest of my client to expose himself to further criminal liability. Of course, plea bargain is very, very, very table. It's very, very, very table to do a case. And I align myself with what Mr. Charles Adeogun have said. If a case is not able to cross-examination, it is irresponsible and unprofessional for any defense counsel to advise their client to plead to such case. I will never do that. If I know on the face of it or at close, robust cross-examination, prosecution case will fall, I will never plead, I will never allow my client to plead to such offenses. No matter how enticing it might be, I will insist on trial because my client's interest is very paramount. I'm not here to increase the conviction rate for prosecution. I'm here to increase, exonerability of my clients. That's my primary purpose under professional conduct rules, which is subject to that issue of me being obliged to pass information and being an officer of the court. And just like what Mr. Charles Adeogun said, in England and other jurisdictions, you get premium for pleading very, very early. At case and plea management, the judge will note when you want to plead. The judge will also note that you have been warned and been given the opportunity to plead. So the issue of plea bargain should not be brought in at last resort when prosecution know that his case is bad. The issue of plea bargain should be proactively addressed by a competent defense counsel as a way to resolving the case which the client is facing. And I'm of the opinion, and I also subscribe to that position as well. So prosecution will not force plea bargain down the throat of defense counsel when they know they can't get their witnesses. They wouldn't do that. If they do that, a competent defense counsel should shut them down and say, look, you can go away with the plea bargain because having seen this case, I think you are going to be able to struggle in getting conviction. And that is what is expected of you. And Oputa JSC, like I've mentioned in the case of Udofia and the state, 1988, LPLR 3305, Supreme Court have said, counsel owe a duty of care to ensure fair hearing for their clients. And that duty of care also include them to be courageous to put their case before the court. That also include them challenging all gaps and inadequacies in the prosecution case. And they should do that to the best of their ability. And when they are doing that, they are doing that in order to serve the interests of their client. And in doing that, they are not in breach of their duty as a law officer to the court. I think I'll commend that decision of Idofia and the state to all my colleagues to have a read, to see the nature and the paramount role that defense counsel ought to play in determining how to go about and take care of the interests of their client. And even more importantly, like I said, I'm a constitutional law expert. All these professional rules are subject to the provisions of the Constitution. Constitution says 36(5), somebody is presumed innocent. So it's not my duty to persuade him to plead guilty against what the Constitution has guaranteed for him. So I don't care what the prosecution case make of it. I don't care what the co-defense lawyer make of it, of my own particular interest. But it's very, very important as well when you have multiple defendants for the defense counsel to work together strategically in fighting off the prosecution case. So they should be able to have confidence and candid and confidential discussion among defense counsel to know how the nature of their plea will interfere or will interface with other co-defendants. That exercise is also very, very important. And I advise, defense counsel to always have the confidence of their colleague in discussing this issue without compromising the interests of their own client. Bearing in mind that people charged under one indictment, they are joint and several. So one person cannot unilaterally protect his own client's interests without working in conjunction with the other people, because the other people might drive your own efforts to futility by not cooperating, by you not coming from the same. And the other risk is also that when you have somebody who wants to plead guilty, you need to be mindful of that intention. Is he plead guilty in order to become prosecution witness? Is he pleading guilty in order to get lesser charge? So all these are very important issues that defense counsel ought to take into consideration when they are discussing the issue of plea bargain. And it is very, very important. One cannot overemphasize it. And I think those are my remarks in relation to all those comments that have come up. And I've also noticed a gentleman was asking, is a lawyer obliged to tell the authority if he knows that his colleague at the time, his client at the time of being briefed is involved in money laundering? I would advise that such clients ought to decline the representation, ought to decline the rule. And if you are declining the rule, you are justified within Rule 24 of the Professional Practice Rules, that you have justifiable factor that inform your decision. I'm not going to represent a client who had informed me that, as a matter of fact, my activities borders on money laundering. And it doesn't, and if there is an obligation for me to report to the authority, I would decline to represent that client. Because once I represent that client and the client has given me that information, then there might be a duty on my part to report to the authority. And I'm glad that Mr. Ogala also alluded to that cases. The case has not been finally decided. Does the money laundering obligation of client reporting, clients, counsel, are they obliged to report any money laundering activities or potential money laundering issue to the authority? I think a client that is robust should, a counsel that is robust and articulate around that issue should decline. Because if you are not declining to act for that particular client, you are exposing yourself to the risk of withholding information which amounts to crime. So counsel need to be very, very attuned to their responsibility, because that risk is also there. That's a separate offense under the criminal code. If you know of a criminal offense and you fail to inform the authority. So in acting for your client, in wanting to do the best for your client, one has to make all these difficult decisions and one has to reconcile them. I think a logical way of going about it is ensuring that your conflicting role as a counsel is always balanced with your duty to the court and with your duty to the authorities. Those are my observations. Thank you.
Thank you very much, Dr. Martins. It's very, very enlightening. Maybe we can take maybe 2 or 3 more interventions here. Like I said, from the perspective of defense attorneys, if there's anything you would like to add or comments you'd like to make, anything that can improve our criminal justice system, anything that can improve on the relationship between defense lawyers and prosecutors, anything that we can see that can improve the way that our courts manage criminal issues. So I don't know if anybody wants, I don't know if anybody from the bench is here. We really did not, I didn't specifically invite anybody from the bench since the issue of professional ethics and conduct in defense of criminal trials is mostly on the side of the bar. But if there's anybody from the bench who'd like to comment, and please go ahead. Anybody else is free to just raise up your hands and give 1 or 2 comments on the issue. From my perspective, basically, I try to discuss, if I'm involved in a criminal trial, I relate a lot with the prosecutors. I even go to the extent of asking them, how do you see this case? Where are we going with this case? How do we ensure that justice is done in this case? I have no problem at all relating to prosecutors on this matter. I think that it's part of what everybody has said, which is, what is my primary duty? My primary duty is not to win a case. My primary duty is to ensure that justice is done. And I owe that duty to the courts to ensure that justice is done. The judge cannot see everything, does not know everything. It is usually what the prosecutor brings before the judge, what the defense brings before the judge, that the judge will apply the law in deciding those cases. So what do we bring before the judge? Is it a lie that we bring to the judge, or is it the truth? Is it the facts that has been investigated thoroughly? There are also issues of prosecutors being hand-tied because the investigation sometimes it's done in a way that cannot expect any prosecutor to do his job properly. And the issue of the defense as well. I've also had concern with the way the courts keep adjourning cases, especially when the prosecution is not ready, or perhaps there's no witness in the case, and the court keeps indulging the prosecution and keeps adjourning the case. And I'm really uncomfortable with that. It's like the judge is leaning towards allowing the prosecution to get its house in order. It is my opinion that their house should have been in order before they even bring the case to the court. But this again, issues of technicalities, issue of governance, issue of funding and financing of police investigations and the Ministry of Justice itself. So these are things that sometimes are beyond our control. But then again, because we are stakeholders, we need to address those issues, talk about them openly, and try and find a solution to them. I haven't seen any hands up, so maybe
Mr. Bayo,
yes.
can I make a very brief comment in relation to the ethics issue
Oh yes, please do.
as concerns defense counsel and the prosecution? In my experience, the main area of where ethics comes into play has to do with the disclosure of exculpatory material by the prosecution. And that is such a live issue for both sides, both for the ethics on behalf of the prosecution and the ethics on behalf of the defense. Now, it is often the case that in the course of a criminal investigation, the prosecution comes into contact with material that tends to suggest that the innocence of the accused. I've been a prosecutor for 20 years. It's often the case that at some stage, there is some material in the course of the police investigation that will suggest or tend to suggest that the accused is innocent of the offense. Now issue comes in, that material then becomes exculpatory of the defendant. And there is an obligation on the prosecution, regardless of the need to secure a conviction, to disclose such material to the defense. That is where the ethics comes in, because the defense is unaware of this evidence, but the prosecution is aware of it, and it's in their custody. And even at the international level, we have been in situations where two witnesses give conflicting witness statements. And of course, we don't disclose both. We disclose the one that aids our case. But we also know that there is another witness that completely contradicts. Now, the evidence has not been tested. The evidence has not been tested. But as a duty, as an ethical duty, most prosecutors are required to disclose both statements and let the defense make of it whatever they want to make of it. Now, the ethics comes in when you withhold that statement that is deemed to be exculpatory of the other side. I would suggest that the duty is on the prosecution at all times to disclose the exculpatory evidence, regardless of the consequence. That's my contribution. Thank you.
I think a very, very important point there. It's something that possibly we can take to the Attorney General in terms of when they're doing trainings for prosecutors. Another important policy that I would like to see being made is where prosecutors are at the beginning of investigation of cases. I think, I don't know, Mr. Charles Adeogun Phillips, what do you think about that? I think the prosecution should be involved from day one in the investigation. Is that possible with our current structure in Nigeria? Dr. Martins, is that possible?
I have often said that the major drawback of the EFCC as a prosecutorial agency, well, it's not a prosecutorial agency, actually. That is where the problem lies. The EFCC is an investigatory organization that also does prosecution. And that is where the problem lies. It should be the other way around. It's the prosecutors that direct the investigations and not the investigations direct the prosecution. So often a time, and I know it's probably not the case with the Ministry of Justice. In the Ministry of Justice, you would find that the DPP has some supervisory and oversight over the conduct of investigations. She may have it after it's concluded. I don't know whether she has it when it's ongoing, but I know that she has the case file is submitted to the DPP's office, following which it is reviewed and opinions are generated thereof. Now that is the proper way that it should work. Now what we need to do is to have the involvement of the prosecution whilst those investigations are ongoing. They need to when we were investigating the George Bush several years ago, everything the DSS did in relation to the conduct of those investigations would land on my table in or they will put me on and they will fly me to Abuja and they will say X and X and X and X material, what do you think? Half the time I threw it out because they were simply shifting the burden of proof on the poor judges to show what is the source of their income. So we had all these bank statements from judges, and some of these judges were not spending their money. And they will come and they will put it on a graph and they will say to me, oh, Mr. Diogun, we've caught Judge X. He's not spending his salary. He should come and show us why he's not spending his salary. And I will say, since when has the burden of proof been shifted on the defendant? You go and show me how the judge is involved in corrupt practices. Don't expect the judge to come and show why he's not spending his salary. Now, that is because I had control over those investigations. And I refused to lay any charges on those judges until I was sure that the evidence was capable of being sustained at trial. Now, I don't see that happening very often, where the prosecutors have some oversight function over the investigators. And we need to do that. And Mr. Martins, who haven't been in the Crown Prosecution Service, will probably be able to shed more light on this in terms of the oversight functions of prosecutors over ongoing investigations. Thank you.
Dr. Martins.
Yes, I think that's very, very concise and simply proved by Mr. Adeogun. As a matter of fact, for serious offenses in England, you need to get prior authority to charge. The police need to speak in consultation to a Crown prosecutor to get prior authority to charge that particular defendant or suspect. So that provides a sifting process for the system in order to make sure that the investigation is robust. And I think that's one of the things that we need to do. But because England being a unitary country where you don't have a federal government and a state government, it's easier. But because of the dichotomy in Nigeria in terms of constituted authority and control of the police, most of the time, the level of supervision that you have in police investigation is subject to the benevolence of the state commissioner of police, because the police is not under the control of the state attorney general or the state government. So that's where the challenge lies. In fact, as a matter of fact, when I came to Crown and to DPP, one of the first innovation I thought of was to start an investigatory unit open to be able to control the quality of the investigation that comes from the police, because you're as good as the investigation report that you have. Of course, to my disillusion, I knew that the police were not ready whatsoever for you to superintend or assist them. And I know that the office of the AG has started the district prosecutor initiative, which is meant to sift the decision-making process through the case file that is brought to court. I think it's very, very commendable and very, very timely. I think one of the other legislation that we need to push for is to legislate the obligation on prosecution to provide information for defense that tend to undermine prosecution case and assist the defense case. In England, you have the CPIA, Criminal Proceedings Investigatory Act. Under that act, the police are obliged to have a schedule of all the materials that are generated in their investigation to disclose to the defense any material which they know would assist the defense case. And under that law, the defense can go to court, go to the Crown Court under Section 5 of that law and compel the defense, the prosecution to hand over information that will go a long way to assist the defense case and support the prosecution's, undermine the prosecution case. So as a Crown prosecutor, also in the US, the vast majority of your time when you are reviewing case is to go through that disclosure unit, to look through carefully, is there anything that undermines the prosecution case and assists the defense case? Because you have the obligation under that CPIA law to forward that information to the defense. So we don't have that kind of legislative framework. Those of you in private sector, and of course for people like us in public defense, this is the kind of legislation that we need to campaign for, that anything that undermines the prosecution case and assist the defense case should be handed over to the defense. This is part of fair hearing. When we are talking about fair hearing, it's not just only for the prosecution or for the victim. The defendant is also entitled rather more largely to a very, very big chunk of fair hearing, because when you have a prosecution that the odds are stuck against the defendant, is in a situation that his fate will be very, very, very precarious, and it undermines the constitutional provision. So this is where I think defense lawyers who are independent need to push for this kind of disclosure responsibility. What is presently available to authority, I think is Okonko, is that there is obligation on the prosecution to over police investigation reports as part of disclosure. Yes, you can get the police investigation report, but how effective that is going to be when the investigation report is so scanty, or when there is responsibility to have something there that will assist the defense, is yet to be decided. So I strongly advocate for a statutory framework to come information that on one case and assist the defense case, and to have sanction within the law, because in jurisdiction where there is disclosure or there are sanctions imposed by professional rules and imposed by relevant extant statutory law, penalize a prosecutor who will hide away cases. And you've had so many cases, so many convictions set aside in UK and US because prosecutions has wielded, crucial information. Birmingham says, and so many other cases like that. I think for defense, for law reform purpose, I think it's very, very important. Thank you.
Thank you very much. And with this, we'll bring this session to a close.
Hello,
yes.
Mr. Bayo.
Yeah, me too. Yeah.
I thought Mrs. Aditu to answer my question. The question I asked has not been addressed.
Hello. Yes, sorry. I'm sorry. What's the question again? Mr. Sawyer. Hello.
Yes, I said that here in Abuja we have this challenge of prosecutors not having enough prosecutors to prosecute in courts. You have situations where you have one prosecutor shuttling about 3, 4, 5 courts. And in most cases, matters are being adjourned if the prosecutor is not in a particular court.
That's very unlike Lagos. That does not happen in Lagos.
Okay.
In Lagos.
So I just want. Okay, I just want you to share your experience with us so that we can also learn from what you're doing in Lagos and then also apply it here.
In Lagos, at the magistrate court, we have prosecutors. We have both the police prosecutors and we have the state council prosecuting at the magistrate courts. At the high courts, we have the state council prosecuting at the high court, and we have sufficient counsel. In fact, in some courts, we have more than 3, 4 counsel prosecuting in that court. because of the volume of the cases in that court, particularly the criminal matters in this court. So there isn't such in Lagos. Probably what they need to do is to employ more prosecutors to prosecute at Abuja. But in Lagos, because of the population and the volume of the cases, we cannot afford to work in such manner.
Okay.
I hope I'm clear.
Yes, thank you very much. In Abuja, one of the challenges they are facing is that they're using the ACJA, which had removed the powers of the police to prosecute at the lower courts. So we did advocate for something like that here, but the AG discovered that if he did that, he would run into the same problems that the SCT is in right now. So in his wisdom, created district prosecutors for 3 divisions of judicial divisions right now, which I think it's 3 or 4. Ikorodu has a district prosecutor, Ikeja has one, Lagos and I think Yaba has one. So basically, those district prosecutors are being stationed there to filter the cases, just as Dr. Martins had mentioned. And I want to appreciate everyone here. Everything that has been said here is being recorded, and as what we did last in 2019, some of the outcomes of our meetings, we sent it before the Attorney General, and we've made some noise about it. Some changes are being made. Other changes that are required to be made may incur some substantial funding. And I think we're getting there. Maybe not fast enough, but we definitely get to where we're going. We need more awareness about these issues. We need to have a better working relationship between the defense attorneys and prosecutors, and definitely the issue of professional ethics across the board is very vital in being an effective prosecutor and an effective defense attorney. Because when we're both effective, then the courts will also be effective. And we can also, in a way, with our effectiveness, we can bring some sanity to the police formations as well. I think we need to do more work in terms of from the police level to the courts. And that is what we need to take away from this. Aside from that, we also need to take away the fact that we have a higher responsibility to do justice to the courts and not to our clients or to winning cases or for the prosecutions to get the highest prosecution rates. So thank you very much, everyone. Hopefully next year, we will do this, not virtually this time, but we will do this face-to-face. And before then, we hope that some of the conversation here, some of the suggestions here would be would have been put into law and would be executed by us. Thank you very much, everyone. Have a lovely weekend, and thank you for being with us. God bless you. Bye-bye.